All right, welcome everyone to a special Wednesday edition of, I don't know, is this the Employer Handbook Happy Hour? I don't know. That's not what today's about. Today is about a very special guest who I will introduce in a second, but I want to thank you all for being here. My name is Eric Meyer. I am an employment lawyer at Pearson Ferdinand. I am also the publisher of the Employer Handbook blog. And again, thank you for being here. The face to my left on this little modified Brady Bunch triangle. I don't know if it's on your left on the screen. I will let her introduce herself. It is Amy Epstein Gluck. Amy, great to see you.
You. Great to see you. As Eric mentioned, I'm Amy Epstein Gluck. I am also a partner here at Pearson Ferdinand. I chair our firm's Employment, Labor, and Benefits Department, of whom Eric is a part, and I am internal employment counsel to the firm. I work with companies large and small on all manners of things governing relating to employment as well as DEI. I have known Eric for almost 8 years now, yeah. And just like you, I first learned about him from his blog. So I'm with you. Thank you for having me to talk to Ms. Feldblum today.
And before I get to our guest of honor, let me dispense with a few other administrative details. First, we are all lawyers, but we are not your lawyers. At least, well, some of you attending today, we may technically be your lawyers here at Pearson Ferdinand, but let's suspend that for the next hour. We're not your lawyers. This is a free Zoom. You wouldn't take free legal advice from anyone, would you? Don't take it over the next hour, please. We assume that all of your questions that you are posing in the chat are hypothetical, that you're asking them for a friend. We'll try to get to them, but if we see the ones that are a little bit too particular, we may pass on them. So try and keep them general. And we know you're not seeking legal advice because we're not giving any and we're not creating an attorney-client relationship. Also, if anyone needs to use the closed captioning, go down to the bottom of your Zoom screen. It's not quite the middle, not quite the right. It's like in right center field down there. Uh, Turn on the closed captions and you should be able to use them. If you have any issues, let me know. Again, we encourage people to use the chat. We'll try to get to as many of your questions as we can, but we have an hour. We want to be respectful of your time, and I don't want to keep talking. Oh, I know people are going to ask this one last thing. Yes, I did remember to hit record. Yes, I will post this on the YouTube channel, and I will share the link in an upcoming blog post and on LinkedIn. And if you're not connected with us, by the way, on LinkedIn, please seek us out and connect with us. Okay, enough of that. Now, I want to turn to the guest of honor, who, for those of you who may not be familiar with her work, Chai Feldblum, her career has intersected with civil rights, employment law, DEI, a former EEOC commissioner. Hi, how you doing today?
I'm I'm busy, but I'm good, and I absolutely appreciate, by the way, Eric, your blog, really what various people are doing in a webinar like this, so we can have an exchange of information about what people need to know without it being official legal advice.
Excellent, excellent. You served as an EEOC commissioner during a pivotal time. What are some of the biggest shifts you saw in how employers have approached diversity and inclusion?
So I would say, being at the EOC, I saw that a lot of employers cared a lot about diversity. It was because they might have known the research about how useful it was for them. It might have been because their employees wanted it, or it was what they needed to attract talent. And while I was there, the Me Too movement exploded. um, it exploded about a year after Commissioner Vicki Lipnick and I had put out a report on preventing harassment in the workplace. So I would say it was very positive, very interested. People cared. People wanted to do things.
I remember those days. I remember you touting the bipartisan relationship that you had with Commissioner Litnick and the ability to put out that workplace harassment guidance. It was special. It was good.
Mhm.
I remember that too. And good morning. No, good afternoon. I'm so thrilled to have you. Um, and we're talking about DEI today. So let's kind of start with the basics. As a former EOC commissioner, you worked, and everybody knows what the EOC is, right? The agency tasked with enforcing the anti-discrimination and anti-harassment laws. The big one being Title VII, which we know prohibits employment discrimination based on characteristics like sex and race and color and religion and such. How does DEI fit in there? Like, what does the law actually say about DEI efforts in the workplace?
Sure. So Title VII itself is not talking about DEI, right? Title VII is talking about not discriminating on the basis of race, sex, religion, national origin. The Americans with Disabilities Act, which the EEOC also enforced, talked about not discriminating on the basis of disability. But beyond not discriminating, right, you want to make sure that when people come in to your workplace, they feel welcomed so that they don't leave if you've made that effort to have them here. Sorry, guys, I'm in a studio apartment in Brooklyn, so there's only one room here for the moment. So you want to make sure that they feel welcome, which means you want to make sure that there isn't harassment, right? You want to make sure there is fair analysis of their capabilities in terms of promotions, etc. So Title VII is about not discriminating, but the end goal of Title VII is about having a diverse workplace. It's about having an equitable workforce, not that you just bring in folks from have different characteristics on these bases, but that they're treated equitably. And it's about making sure that people feel included so that they don't want to leave and that they do their best work. So diversity, equity, inclusion, it is built into the bones, I would say, of an anti-discrimination law in terms of what you want to achieve.
I got it. When you say, I'm going to go off key for a second. When you say treated equitably, what does that mean? That's the number one of the top three questions I get from clients is what's equitable? Why is that different?
Yeah. So imagine this, treating someone equally means treating everyone the same, right? But let's say you say, oh, everyone comes in the front door. Everyone comes in the front door. We're treating everyone equally. But if you're using a wheelchair, that doesn't help, right? Because we're not all similarly situated. So treating people equitably means treating them as equals, treating them in a way where you understand how are they currently situated, and therefore making sure that you're doing something that lets them flourish completely in your workplace. That's the difference.
Got
That's
it.
the difference.
That's a great explanation. Thank you. So this all sounds very logical and very rational. So when you hear like CEOs or business owners say, well, DEI is a legal minefield, what does that mean to you? Like, do you think that that's true? Do you think that that is a misunderstanding? What are your thoughts on that?
I think it's true only if you're not doing diversity in the right way. It is
Okay.
not at all a legal minefield if you are trying to achieve diversity in that correct manner. I mean, that's why, and I know we'll get to it, that's why it's so unfortunate that the EEOC now, I don't want to say EEOC, it's acting chair Lucas. It's one person who's doing this. Only two people at the EEOC right now. But it's so unfortunate that the message that's coming out is that DEI itself is somehow problematic in terms of legal risk. It's not. It's how you achieve that diversity, that equity, that inclusion. Okay. So if you're an employer and you say, oh my goodness, I'm looking around and I really don't have diversity, whether based on race or sex, religion, Okay, well, the most efficient way to achieve diversity is to say, out of my next three hires, one of them is going to be a woman. Or out of my next three hires, one of them is going to be a Black person. I mean, logically, that's the best way, right? Logically. And in fact, in lots of places in Europe, they have quotas. So you have to do that. While that may be logical, in this country, it is not legal. And it's not legal because the law doesn't say you can't discriminate against Black people. Because if it said that, then you could discriminate against white people. It says you can't discriminate on the basis of race, on the basis of sex. So you cannot take someone's race or sex into account to say, we are going to hire this person. That's it. So if you do diversity in that way, that's a problem.
Right.
Now, it's not just that you don't do it that way. Your hiring managers need to understand that that's not how they achieve results. And that's where I think employers have not been as careful as they should be. And where they say, we're going to judge you based on how diverse your team is, and we're going to look at those numbers. Oh, but by the way, don't take that into account. I mean, what are you going to do if you're a hiring manager,
Mhm.
right? So given the laws, you need to be thoughtful as an employer. You need to be thoughtful in your hiring practices, which is why lawyers here, when they do give actual legal advice, we're giving legal advice to
Sure.
ensure that our employers that we're counseling are doing the right thing.
Yeah. Yeah, that makes sense. Why do you think, so given that explanation, which is excellent, why do you think there's so much confusion right now about whether employers' DEI initiatives are lawful or unlawful? Um, where do you think the confusion lies?
So I think the confusion comes from two places. The second place is new. Okay, it's sort of the messages that are coming. The first place is based on what I said, that people, if they care about diversity, for example, what they'll do is say, well, you know what? Let's create some aspirational goals. Now, aspirational goals are good. I think goals focus the mind. But if you're going to do an aspirational goal of percentages, women, people of color, etc., you cannot just make a number you can't pull a number out of the air. You actually have to look at what the jobs are, what the qualified labor force is for those jobs. Based on that, you figure out an aspirational goal that is realistic. And let me tell you, that's not cheap.
Right.
That's not cheap to try to figure that whole thing out. It's much cheaper to just say, well, we're going to say 20% and, and think that you're going to be okay because you say it's just aspirational. No, because people are going to be trying to then meet that goal and maybe they'll try to meet it in a way that's not legal. So I'm all about focusing the mind, but I've never felt that aspirational goals are necessarily the best way to do it. Number one, because to do it right, you have to spend a bunch of money. So if you did, I like those. But there are other ways you can achieve diversity without having to try to have an aspirational goal.
Got it. And you think that is contributing to the confusion around the
Okay,
legality initiative?
legality, right. So there's stuff that's happened before now, right? And before now, I think everything could have been addressed by people just getting good lawyers and lawyers who were not going to be risk averse in a way that was not necessary to be risk averse, which was certainly often what general counsels, they were like, let's be the, most careful, quote unquote. So I think that there was a sense of legal risk, but only because sometimes it wasn't done correctly, whether it was creating expectations of managers or creating aspirational goals on a macro level. Now we're in a different situation. Now we're in a situation where we have executive orders that essentially collapse an effort to achieve diversity with an assumption that you're not hiring or promoting based on merit. right? You look at the language, they're actually collapsing that and saying people are being hired, people are being promoted because of their race or sex and not because of merit. Now, that is simply not true about DEI. But if you're being sent that message, you as the employer need to sit back and really make it clear that you are focusing on merit. You are focusing on qualified employees, and these are the completely legal methods that you're using to get there.
You fed me my next question. Look at that. Great minds are thinking alike. So I want to talk about that for a second with you about that line, that boundary, right? Like legal boundaries and otherwise, between, and I think that's really what employers want to understand. It's hard for people to understand that there's no bright line rule, right? An employment lawyer's most quoted response to things is, well, it depends, and employers don't love
That's
that.
my line.
I know, I know. I co-op, so we're sharers here at this firm. But I want to talk to you about the line between like inclusion versus preference. Like, is there a line? Where is the line? Like, is the line Black History Month or Autism Awareness Month? Or is the line internship programs geared toward diverse people? Like, help me understand those legal boundaries. Help everyone understand.
Right. So there are probably two main things to keep in mind in terms of the boundaries. One is preference, and the other is exclusion. Okay. So preference, you cannot, and again, this is very difficult to absorb because it's so counterintuitive to the ultimate goal of diversity, right? Like I said in the beginning, the best way to get to diversity is you have two people, three people, they're all qualified, in different ways. All qualified in different ways. You're going to choose one. Well, as you're looking at all their qualifications, one of the things you want to look at is would they bring diversity, race or sex? Well, it's not that you ignore that because that's just part of who they are, but you can't use that as the deciding factor. Now, look how blurry that is, right? Of course, that's blurry, but this is the world we live in. We live in a legal world that says that cannot be the deciding factor. But we don't live in a world that says you have to ignore the fact that they have certain experiences because they're Black or they're a woman, et cetera. Now, I cannot use the example disability because that is the one you can prefer someone because they have a disability. You can prefer someone because they're over 40 years old. Those are you can do preferences. But if it's not disability or age and it's protected characteristic, race, sex, religion, national origin, you cannot do a preference. So that's the dividing line. And I know it's blurry, but it doesn't mean it can't be absorbed and done correctly. Okay, so that's one thing, preference. So an internship, you don't want an internship that is, hey, this internship only for people of color. And I know people have done that, but that wasn't, and forget about anything recently, that wasn't, necessarily the right approach. I mean, one could have argued the legality at the time, but again, being strategic, that's not what I would do. As opposed to, there are lots of folks who come from backgrounds where they're not necessarily going to know about an internship program. I mean, I grew up family, very little money. I did not know any lawyers until, I got to working in, you know, Capitol Hill. It's that's it. There are people for very different reasons that may not know. So of course you can have an internship designed to increase your diversity. It's just on a range of issues. Okay, so not preference, but openness. Two, not exclusion. So for example, the concern that in the DEI related discrimination, look, even at that title, DEI related discrimination makes you feel like there's a lot of possible discrimination in DEI writ large. And no, there's not. There's discrimination in preference and in exclusion. But in that quote unquote guidance or fact sheet, it says, sort of be careful about setting up affinity groups because that could, lead to segregation. No, you can't have an affinity group that excludes people, but you can absolutely have an affinity group that is centered around issues that affect people who are Black or who are women. It just can't be exclusive. And it's so interesting because in the LGBT affinity groups, they're always called LGBT folks and allies, and as someone who is a lesbian and has worked in this area for years, I think we just knew as gay people that we needed to have allies. And so that was just normal. That needs to be normal for everything else. Now, you can't have something around issues of women and have someone wants to join the group who believes women shouldn't be in the workplace. I mean, you can obviously have the objective of the affinity group be a certain objective. You cannot exclude people based on the characteristic they have.
That's a great answer and really helpful. I especially like what you said about everybody being qualified, it's and your own background. It's a matter of like, if you will, widening the playing field. Is that accurate? Like
Yeah,
not
yeah.
just from as a lawyer, not just interviewing people at Ivy League law schools. That's not a thing for law, but top law schools, looking at state schools as well.
hmm
It's a
Or
great point.
just going into different neighborhoods, like for an internship. So I was lucky. I came from a very educated family, even if it didn't have, we didn't have a lot of money. So, you know, I went to an Ivy League law school and then met people who had backgrounds very different than mine. But you're going to have other people who didn't. So, yeah, from where you're recruiting in terms of law schools. But if you want like an early internship piece, you're just going to different places,
Yeah,
going
yeah,
to different places.
that makes sense. So do you think, you know, um, do you think we need like a reboot on designing DEI initiatives, or we shouldn't be designing DEI initiatives at all?
Oh, uh, absolutely should be designing DEI initiatives because those are the best, that's the best way. If you have good DEI policies, programs, you're going to have a more diverse workplace, which means you're going to have a better bottom line. And it means you're going to be better protected from any lawsuit. Bottom line, someone's bringing a lawsuit, they're going to look at the statistics in terms of your demographics. So you want to have decent demographics, right? So both for, you know, money purposes, productivity purposes, you want diversity. For legal risk purposes, you want diversity.
Yeah,
Okay. But, I don't know that I would call it a reboot. I think I would call it, a refresh. Like, look at everything you're doing, make sure that you don't have either preferences or exclusions. That's for sure. And then think about other ways to do, to ensure not just diversity, which is very much important in terms of recruitment, where you're going, in terms of, oh, sorry, guys.
okay.
Sorry, that was just a bunch of water on my computer, but I'm going to be given a towel now.
They're
Oh
done
no.
that.
This is the problem when there's another person. Um, um, so obviously you want to do it in terms of recruitment. You want to do it in terms of training of people who are doing the interviewing and the hiring. I love that. We've all been there. Hi, thank you.
This
Um,
happened to me during a presentation in front of 200
yeah,
people. Like
yeah.
this did
Okay.
happen.
So that's in the recruitment, but also in terms of the inclusion, right? Making people feel included so you have retention. So you have retention. Don't just do, well, this is coming from my personal perspective, but don't just do an anti-harassment training, which you absolutely should be doing. Do not be scared away from doing anti-harassment training. That's so important in terms of mitigating legal risk, but also give people training on how to engage in civil behavior. Because when we did that task force report, one of the things that a researcher said was uncivil behavior is a gateway drug to illegal harassment, right? If you set up a workplace culture where people respect others generally, where people are respecting other people's physical boundaries, that makes a difference. So literally, I just did a training last week, right? The first hour was respectful workplaces training. The second hour was anti-harassment
Mhm.
training, and then the third hour, skills building, and how do you respond when someone is engaging in uncivil behavior, right? So it's like, it's a refresh. Let's take another look. Let's be as effective as possible.
Yeah. Yeah. Okay. Thank you so much. Those are great, really helpful.
I'm going to pause here just for a second to reacclimate the group. It's almost 12:30. We're about halfway through. This has been wonderful so far. I haven't had to do much speaking, which is great. But we have Chai Feldblum and Amy Epstein Gluck, and I'm Eric Meyer. We're talking about DEI in the workplace. And all right, warning, this is where we're about to get like mildly political because I think we have to at some point. So please don't go crazy in the chat, folks. But I do want to ask Chai Feldblum, you are, I'll just say outspoken, or I'll put it politely. You publish a lot on LinkedIn, which is great for people who want to stay in the know. And a lot of your posts have pushed back publicly on the EEOC's current guidance on DEI, which was issued last month. It's a technical resource document. It does not have the full force of anything binding on employers. It literally is just that. It is a resource document that was issued by a non-quorum from the EEOC. Notwithstanding, Hi, was there a moment recently where you thought this is exactly what I feared would happen?
Um, I don't think I ever anticipated the extent of what has happened. I really didn't. I mean, obviously, people have different views, different perspectives, but I mean, the fact that, for example, I mean, obviously the LGBT stuff is most clear because if you have an EOC that says we're going to operate on the assumption that there's only male and female, and therefore transgender people do not exist, essentially, how can they be enforcing the law? I mean, the Supreme Court has said gender identity discrimination is a form of sex discrimination. Which they said, by the way, because of some of the work we did at the EOC before that Supreme Court case of Bostock. So that to me is like beyond belief. How can you like publicly say that you're going to work the agency in a way that is inconsistent with the law? So, for example, sure, that was unfortunate that the EOC withdrew from the 7 transgender cases they were doing. But, the EOC can decide what cases it wants to pursue, but they can't decide not to treat a charge from a transgender person completely consistently with the law. So I have been surprised by the extent of it. It is true that I am now spending a fair amount of time each week analyzing documents, cases, complaints, and putting it out on LinkedIn. And I encourage anyone who is on this webinar right now, definitely link in with me at Chai Feldblum. Um, it feels, I feel like I can help inform people and educate people so that they can continue to do, to be honest, what they want to do because they know it's the right thing. So that's why I've been doing it.
So in that vein, Chai, some employers are reevaluating their DEI efforts because of recent legal and political developments. Are there specific activities that employers should now approach with more caution or confidence?
So let's go back to that refresh idea, right? Employers should definitely look at whether they have been taking steps that have been preferences or that have been exclusionary. So it's not so much that they should approach certain activities with more caution. They should analyze the activities that they've been doing and not be doing something that is not consistent, right? I think, though, this is the moment in time to actually redouble your efforts if you're an employer to make sure that you still have diversity, that you still are treating people equitably, and you're still making people feel included. Because, particularly in this social environment where people who are not the majority race, I mean, women were basically the equal, but based on past discrimination, may not feel as comfortable. Um, People now who have those characteristics feel a little more scared, feel a bit under attack. And that's going to affect them in the workplace. It's not like I know for those of us who have watched Severance, right? It's not like you walk into your workplace and suddenly you forget anything that it's happened outside. You bring that in. So if you want folks to be productive in that workplace, it's almost like you need to, as an employer now, make sure that you are countering the fear. Make sure that people are feeling included when they walk through the doors of that workplace. And here's a very practical suggestion for that. Like I said, you do not want to stop any anti-harassment training. If anything, redouble your efforts. Make sure you're getting good anti-harassment training, not off-the-shelf training. And as this was a management lawyer that I heard this from many years ago, training is not about changing your behavior. Training, anti-harassment training is not training to change your mind. It's training to change your behavior, right? So you say, well, what's the problem saying you look sexy in that dress, or you look great, in short skirts. You should wear those more often. I say, my wife loves it when I say you look sexy in that dress, right? I'm like, look, we're not trying to change your behavior about what you think is a good thing. Go home, say that to your wife. You probably need to say it to her more often. But when you walk through the doors of this workplace, this is the type of behavior that we will expect out of you. And if, and again, that's the same thing in terms of the respectful behavior, that will make people feel safer in your workplace and it will make them more productive. So now more than ever, I would say have affinity groups and just make sure they understand the boundaries. Do good anti-harassment training. Invest in in-person and anti-harassment training because that will help you.
Aim, what do you think? Do we want to talk about the BigLaw EEOC settlement fallout? I figure we're going to touch on it a little bit.
We could touch on one question.
All right.
By being very, very, very concise, which I appreciate. So it seems that four of the richest big law firms entered into a settlement agreement with the EOC as part of the agency's investigation into their DEI practices. Four have done that, four are fighting, right? These firms that settled basically had to say, okay, we won't do DEI anymore. How did you feel about that? What was your reaction?
Okay, so let's unpack this a little because what is it that they really agreed to do? These four law firms that just settled on, let's take the ones that settled on April 11th, as opposed to the ones that settled earlier. Because of those, three of them had received the March 17 letter from Acting Chair Lucas asking, 30 some questions, typical RFI, request for information. I'm assuming most people in this webinar have received one of those from the RFI, from the EOC. It made me a little crazy sometimes as a commissioner. I'm like, we're asking them all these questions? Like, why? But whatever. They're very broad, right? Ask for a lot of information, including some personally identifiable information. So March 17th, they get these letters. Three out of those four law firms that settled on April 11th needed those letters withdrawn. By the way, now if you notice, but the one law firm, Caldwell, that didn't need a letter withdrawn pledged $100 million in quote unquote pro bono work. The three firms that needed the letter withdrawn paid 125 million, pledged 125 million. I consider that like the 25 million extorted by EEOC just to get a withdrawal of letters and requests for information that Acting Chair Lucas had no legal authority to ask for. No legal authority. The EEOC cannot just randomly send you letters and ask for information. The statute doesn't allow that. EEOC has to have a charge that some individual brought to the agency, or the commissioner can bring a charge under penalty of perjury, believing that there's reasonable basis to think that there's discrimination happening. And once that charge is sent, then the EEOC can send out a request for information, but it's all confidential. It's all confidential.
Mhm.
Here, they ask for information that they had no right to ask for, and there's no assurance of confidentiality.
Sure.
Okay. But now, but they're settling, right? So my feeling is when you say they're settling, say they're not going to do DEI, all we know about what the settlement was, we have two sources of information. We have President Trump on Truth Social, and that's where we got item number 4, the letters, they will not do, illegal DEI, and the letters will be withdrawn. And then you have the press release that Andrea Lucas, Acting Chair Lucas, put out to say what those law firms had to do. We actually don't know if they had to do more because, again, the settlement is not public. But basically, what they had to do was stop doing illegal DEI. Well, hello, they shouldn't have been doing, right? Illegal is preferences and exclusion, right? And when they do legal things like provide people accommodations, have equal employment opportunity, have accessibility, I mean, these are not just legal, they're legally required. They may not call those activities DEI. That's the settlement, part of the settlement. Do
Hmm.
not say DEI. I mean, from my perspective, I was saying a year ago on this, say less, do more.
Right,
You
right,
know what I
right.
mean? On the refresh, I don't think employers should stop saying we care about diversity, we care about equity, and we care about people feeling included. And the idea that this is somehow a dirty word is to me a really sad statement. But it's not the most important. The most important is what you're doing.
Sure. Actions speak louder than words. I have one final question on the law firm situation. How do you think this is going to affect other firms? I mean, we've got the big law firms and we've got 500 plus law firms, of which we are one, who supported Perkins Coie's lawsuit against the executive order. So, how do you think these settlements and such, and Lucas's tact of sending these letters without any authority and whatnot, whatever the minutia of that, how do you think that's going to affect how other law firms, large and small, manage their inclusivity programs, their equitability programs? I'm going to make up new names. They're radical inclusive.
Well, here's what I'm going to say about that. You know what that's going to depend on? It's going to depend on I just looked, how the 303 participants on this webinar go back and talk to their employers, whether they're internal to a company or organization or advising them, and any number that will be watching this afterwards. How law firms respond is going to depend on the people within those law firms, right?
Gotcha.
What they're being advised. And my advice is if you concede and if you settle with things like also saying we'll never call it DEI, you have tainted your reputation. And you don't get that back.
Mm.
You don't get that back. You look at what the law students are doing now. They have their whole spreadsheet of what every law firm is doing, including smaller law firms. You know, obviously, every law firm should continue to do only what is legal in terms of DEI, right? But not to submit in a way that's going to harm their reputations forever. Um, and not advise their clients well. I mean, if they're doing something, how are they going to tell their clients to do something different? They're not going to be good advisors, right? And again, this is part of having an outside, you know how in other countries there's like shadow cabinets when you're not in power, so the people who are experts are there. So I sort of feel like what we've set up, which is I'm now calling it the EEO Leadership Group. So it's like a shadow cabinet for EEO, and the website just went live last week. So some of it is still under construction, but it's at eeoleaders.org. And if you go to eeoleaders.org, you will see our response letter to Acting Chair Lucas on her March 17th letter, our response to the, fact sheet on DEI related discrimination. We've been talking internally. Is there something we can say about these settlements that will be helpful, literally answering exactly your question? So if we end up writing that, that'll be on the website. Um, I think that's the best we can do. Those of us who care about supporting employers who care about DEI.
And let's look
And
at that.
Eric,
I'm
I know
sorry.
you will put that in your blog. I know you're already writing a note. eeoleaders.org. Make sure to put that in my blog.
I certainly will. I
I
certainly
did
will.
refresh.
Oh, and by the way,
Yeah,
I haven't said this publicly to anyone else. So you all on this webinar right now, you're the first ones to know that eeoleaders.org is now live.
scoop here on the Wednesday Zoom. I love it. For our audience who maybe don't work at a law firm, good for you. Employers generally, in-house counsel live in fear of the lawsuit. Chief human resource officers may get pressure from the C-suite to walk back DEI goals. There's a lot of that going on right now. We've talked about now's a great time to really redouble your efforts on DEI to make people feel more included, more welcome in the workplace. Diversity. Businesses, it's shown, do better when you have a diverse workforce. But what's your message to HR leaders or in-house counsel who are feeling caught between business values and legal risk right now?
What I would say is really understand the actual legal risk. So when you are quote unquote doing that trade-off, it turns out not to be a trade-off between business values and legal risk. You see what I mean? You know that the activities you're going to undertake are activities that are perfectly legal. And those perfectly legal activities um, align with your business goals. So the way you described it, they're walking back from DEI goals. Well, goals. So are they, this is the refresh. Has your entire thing been, we're going to get X percentage of women or Black people or other people of color? If that's right, yeah, you want to walk back unless you've spent the money to actually make those realistic. And you've communicated the message to your hiring folks. Just because we have aspirational goals, that doesn't mean you should be using a preference. Okay. But you shouldn't be walking back from your goal of having a workplace in which there's diversity, equitable actions, and inclusion. You don't walk back from that, and that does not have legal risk. That aligns well with your business goals.
So, what's the biggest myth? Let's bust it right now. What is the biggest myth about DEI related discrimination that's going on right now?
Well, I think the biggest myth about DEI is what these executive orders have been doing, which is collapsing. If you do DEI, you are by definition not hiring and promoting based on merit. I mean, that's actually a falsehood. I don't even know how to call it a myth, but that is simply not true. Okay. And then the second, I would say, big myth is almost anything I do to try to achieve the outcomes of diversity, the outcome of equitable treatment in the workplace, the outcome of inclusive feelings in a workplace, the myth that anything I do on that is going to carry legal risk. And therefore, I now have to balance between legal risk and business, values and goals. No, no, it's about educating yourself to know what does not carry legal risk. And by the way, I'm not saying it doesn't carry the fact that the EEOC, some commissioner might want to bring a charge saying it's, you know, illegal. We are not in normal times in that respect. So I'm not being, it's not like I'm not very aware of that. But that's not a reason to stop doing things that are perfectly legal and will achieve other business goals.
Or likewise, I don't mean to pick on these four law firms, and I'm not suggesting that they've done anything illegal, but a settlement with the EEOC doesn't preclude an employee or an individual at one of those firms from bringing a charge. That sounds in, again, we'll just call it generally DEI related discrimination. Like that's still in play.
That is completely in play. And again, when I was saying we're thinking about, that's something I said in my own LinkedIn post. Number one, dear EEOC, you cannot call something a settlement if you haven't had a charge. There is no settlement for without a charge. You have now an agreement, right, with these folks. And note in the press release, EEOC didn't say, and we won't press any charges, bring any charges against you. That was in Truth Social from Donald Trump. We're going to withdraw the letters and we won't bring any charges against you related to the issues in that letter. Well, that's sort of like, thank you for sharing. All that means is you won't have a commissioner's charge, maybe, because when I was a commissioner, no other commissioner and the chair could not tell me what commissioner charge I could or couldn't bring. That was up to me. So, and you certainly can't not investigate a charge that's brought by an individual. Some individual wants to say, oh, I'm going to go after one of these firms. I'm going to bring a charge. And let me tell you, uh, we don't know, and we need to know whether the EOC is not investigating charges brought by trans folks alleging transgender discrimination. Like, we don't know whether those folks are just getting a right to sue letter after a week with no investigation, which I think would be legally problematic, but we just don't know. It's not going to be the case if someone brings a DEI related discrimination claim, which of course is a claim that's based on clearly evidence of preference, clearly evidence of exclusion. You think the EOC is not going to pursue that just because it's one of those four firms? Why? They're desperately looking for people to bring those charges.
Right. Well, we've talked about how the letters DEI really don't have any significance legally. I mean, you could
Mhm.
rebrand and it's not going to change whether the program is legal or not. Those three letters really have no impact on that. But what about culturally within an organization? Do changing those letters, do you think it could have an impact positively or negatively culturally on an organization?
I think it can have a negative impact depending on how it's done. I'm not so sure I would say it could ever have a positive impact, but I do think I would say a refresh can always be good, right? I would strongly urge folks not to get rid of the word diversity, right? To get rid of the word, we want to treat you in an equitable manner. don't get rid of the word, we want to have an inclusive workplace. Those concepts, they aren't really other words that naturally substitute for that. Okay. It's just put it in a bigger context. So, for example, respectful workplaces training is about creating a respectful and safe workplace, which equals inclusion. It results in a sense of inclusion. I don't think you should get rid of the word inclusion because that's the outcome of a respectful, and safe workplace. So I think, and I cannot fault any employer that says, I'm not going to use the word DEI. I cannot fault them in these times that are not normal, but it should be approached as a refresh, right? And the words themselves do not ever, if you enter in a settlement, say, I'm going to enter in a settlement which says that I will never use these three words, which is what those, four firms have agreed to. And what sort of message does that send? And like I said, you lose that reputation. The law students who have a choice among firms, they are not going to forget this.
I think that's right. And you're reminding me of when we first met, when you were talking about the EOC's roadmap to preventing harassment and discrimination. And I had written that I agreed and that having a more diverse workplace, which was based on research I read that the EOC got from a University of Michigan professor, led to inclusion, which therefore then prevented discrimination and harassment as a matter of course. So I take the argument. Now, I think you've answered this next question, but in these last few minutes, I'd love it if you could put it all together for us. Like for employers who are going to continue with the mission of DEI, but they're not sure what to do next. How do they start? How do they move forward? What are practical steps that employers can take to align their values and the law? Like, are they first looking at their websites and their messaging? Are they deleting their pronouns? Does it depend whether they're government contractors or not? What are the steps? Can you list those for us?
Yeah. So the very first step is to have real clarity on what is still legally fine to do, and do not delete or stop doing anything that's legally fine. Just do not. And so you could go to the eoleaders.org website and download what we described as perfectly legal. Just you saying that makes me think we should have another document that says, what should you not stop? Certainly do not stop people putting their pronouns, in their emails. I mean, do not stop that. Why would you want to stop that? I mean, that's just sending the most horrible message of exclusion, right? Look at everything you're doing and figure out what is completely legal, and then have a sequential set. This should be high priority, right? High priority, but not starting with the website, right? Although obviously that's in it, right? Starting with what I'm going to do. So first thing you're going to do is you're going to convey a message to your employees that you still care. You still care. Like, that's number one. And you're not going to do anything that indicates that you care less. Okay. Number two, even if it's not time for your anti-harassment training, maybe think about doing that training now. Think about whether you want to add respectful workplaces training to that. Okay. So that's number two, redouble on the training. Number one, also for that, because you don't want people starting to act in a way that they feel they can act now, given what's being said in the general culture. And that's going to really mess you up legally. Talk about legal risk. Okay. Third, I would say take a look at if you don't have an affinity group right now, this might be exactly the time to do it. So this is when people might be feeling that they need that help. And make sure that the affinity groups are completely operating consistent with the law, right? And then I think the next is, make sure that you're doing good recruitment. Make sure that you are keeping track of your demographic statistics. There's nothing illegal with keeping track of that. In fact, expand, take a look at what the statistics are in terms of your promotions. The other thing that stops harassment is if people who have those characteristics are higher up in leadership. You know, really be clear over the next year, track your retention rates. Track your retention rates, see if that's affecting your demographics. So this is a moment to do more. It's imperative to do more. Just do it smart.
So what keeps you optimistic about the future of workplace inclusion, even amid all the scrutiny and what we've discussed over the past 57 minutes?
Yeah. So in my work, like literally over the last whatever 40 years of working, um, 46, I don't know. Um, I've always considered myself an optimist. And to me, an optimist doesn't mean, like Pollyannish, oh, everything's going to be fine. No. An optimist is someone who takes a look at the landscape, really understands the reality, and then says, okay, how can we move forward from this reality? Like, so that's the orientation. That's the optimistic orientation, not to get dragged down by the landscape that you're evaluating. Now, I'm not saying that that's easy, especially in times like this that are not ordinary, but it's still possible. In exactly everything here we talked about on this webinar, what keeps me optimistic, to be honest, is the 2 years that I worked at a law firm and counseled clients, and I saw the commitment inside companies, small, medium, large, for profit, not for profit. People inside cared. I mean, and that was obvious to me in a way that I wouldn't have seen as an EEOC commissioner for 10 years because they were just seeing all the charges. That's what I believe that's part of the landscape. Part of the
Mhm.
landscape now is an EOC that is very different, but part of the landscape now is still employers that care. That's what I've got to go on.
Love it. I love it. So if you had 1 minute with every CEO and business owner in America, what would you say about the importance and legality of DEI?
And we've got like 1 minute left, so
There are tons of things you can do that will advance diversity, ensure equitable workplaces, and reinforce inclusivity. Find out what those things are, start doing them, and as the CEO, send the message that this is what you're doing. That's what I would say.
well,
Wow.
thank
12:59.
you.
And
Yeah.
save the chat. There were tons of I couldn't read all of them, but definitely save the chat and I want to see it. And if I can answer some of your questions in a LinkedIn post, I will do that.
So
So take the last minute, or send them to Eric's blog. I don't know.
you can reach out to us on LinkedIn, folks. I'm going to post this to YouTube. I'm going to run this through AI and I will digest this into like a pretty clean synopsis. And hopefully I can pull out some of the questions and we can get them answered for you without providing any legal advice. But I want to thank Amy. I want to thank the audience. And I want to thank, most of all, Chai Feldblum. Thank you so much for being so generous with your time over the past hour. It's great to see you again, friend. Thanks for doing this.
Same here.
All right,
Take care,
folks,
all.
get back to your
Bye.
day. Thank you. Again, it's going up on YouTube and see you later. Bye.
See you later.